Welcome, everyone. My name is Jen, and I just wanted to welcome you to today's training. It's on the court review of placement in the Qualified Residential Treatment Program, otherwise known as the QRTP. And today, I just wanted to go over first some housekeeping matters. You will, as in other trainings, if you have participated before, you will not be able to unmute yourself. We've had hundreds of people as participants, so we just have that feature for this training. What we would like is if you could please post questions in the Q&A, and we have a little graphic here with, as you can see, with the green check mark under Q&A and the two little text boxes. You can use the chat and the raise hand, but we probably won't see it. I won't see it just because I'm presenting my screen. And the slides, Eric has put the slides in the chat feature. So if you go to the little chat box, I don't know if you can see my arrow, but I'm pointing at it, but there is the chat box will have the slides in it for you to follow along if you want to do that as well. And this presentation is being recorded and will be available at the Minnesota Child Welfare Training Academy webpage. And we will have the link later on in the presentation, but it's also as a connection here. And then lastly, if you are looking for continuing legal education credit, I did apply for some because I need credit. So this is the event code 404253. So as the Minnesota Child Welfare Training Academy, they will have all the information for you so that I will be keeping that for you to be able to get credit. And if you have any questions, you'll be able to contact me. I can put my information later on in the chat. So what I wanted to do is just kind of introduce you to our presenters today. There will be 4 of us. And first of all, just welcome and thank you for joining us. We're really pleased to be presenting. I'm the DHS CJI and Title IV attorney, and I started my juvenile law career in 2000 when I started clerking in juvenile court. And one of my favorite professional experiences was when I was working under a grant with the Indian Child Welfare Act Law Center. And I worked with law clerks and pro bono attorneys, mentoring them on various child well-being cases. And then Paul, he is an attorney that I work very closely with and honored to work with him. He coordinates the education and training voucher program at DHS. He has almost 30 years of experience in child welfare, working with tribal, county, and nonprofit social service agencies. Previously, Paul represented parents in Indian child welfare proceedings, the Leech Lake Band of Ojibwe and Ikwa proceedings, and helped develop and implement Indian child welfare quality improvement processes specific to state child welfare agencies, both in Minnesota and nationally. Becca is a staff attorney that I also work closely with and also honored to work with her. She's with the Minnesota Judicial Branch's Children's Justice Initiative program. She's not on right now, but she will be joining us shortly. She's actually doing another training. Prior to her work with the CJI program, she worked as a staff attorney for the Self-Represented Litigant SRL program, where she served thousands of self-represented litigants, focusing primarily on the areas of juvenile law and family law. Before working for the courts, Becca worked at the Ramsey County Attorney's Office in Child Support Enforcement. And lastly, Eric, I have been working closely with him recently just on these trainings, but he is our SSIS training lead with DHS and also a liaison for the related training to the Minnesota Child Welfare Training Academy. Eric also has nearly 30 years of experience working in health and human services. He started in direct care for clients living with brain injury. For much of his career, he provided independent living services and case management for clients living with cognitive and physical disabilities. So we're just so pleased to have someone that has had so much direct contact with us today. So thank you, Eric. And then this is the agenda for today. I will be going over the introduction and federal authority. Paul Meinhardt will be going over the state authority in the Minnesota court process. Becca will be going over the court review, and Eric will be going over SSIS. So first of all, for the introduction, as if you have been participating, you are well aware that we have done hours and hours and hours of training. And if you have not been able to participate, or if you just want to watch the trainings again, they are at this website, the Minnesota Child Welfare Training.com. And there's also other links on there that are very helpful. If you haven't been to this website yet, I highly recommend it. You can even, if you have multiple screens, it's kind of nice to just go to as well for a wealth of information. And this is kind of the nuts and bolts of what we're going over today. The QRTP is a very small part of the Family First Prevention Services Act, but today what we're going to cover is the qualified the QRTP and the court review process. So as you can see, I am a journalism background, so I like to just do the 5 W's and what's going on. So who we're talking about are children in group settings, that congregate care setting, and what is the FFPSA and the QRTP. Where is our 87 counties in Minnesota, which also known as local social service agencies as a legal term. And then we have 3 initiative tribes. And when, so the initial placements in any certified QRTP on or after September 30th, 2021. So we're at September 9th right now, so we're getting close. And the why, we want to strengthen current Title 4E protections. That's the federal law in our US code, and then also our Social Security Act that gives children and families the most protections when we are taking children away from their home. We want to make sure that they're in the most family-like home settings and keep all the stakeholders, us, with child welfare, not child welfare only, but child well-being in the forefront of our minds. And how the new law protects that is basically limiting that $4E and then moving it to prevention. And with our 4 Title 4E funded non-family placements, that funding will stop after 2 weeks if the placement doesn't meet the new law. So what has started all of this? We're working under federal authority. It's federal law. As you saw earlier in a slide, it was passed in February 2018. So a team of us and a bunch of other groups, stakeholders have been working since February 2018. So for the past 30 months, this is what we've come to, and this is our authority. This is the law. And you can find it at the US Code or the Social Security Act, just like you would find other Title 4E authority. And for court review, what the law says is within 60 days, this placement in a QRTP setting has to be reviewed by the court. And the law actually gives more room than just the court, right? Because the court, it's saying here, an administrative body appointed by the court. So Minnesota has not decided to do that administrative body that's going to approve QRTPs. What it's going to be is the 87 counties and the 3 tribal courts that will be approving those placements within 60 days. And if the judicial determination is not made in those 60 days, that's when the reimbursement for the placement will stop. And so under FFPSA, again, just repeating that it's a 2-week period. So it's a very short period than what we're used to currently. So starting that 3rd week of the child's placement, the 4E funding will stop unless it's under one of the 4 types of non-family placements. I'll show you in the next slide. And of those 4, so these are the 4 you will see. And next week, I believe we have, and the week after, we have trainings on those other non-family placement settings. But today, what we're concerned about is number 4, the QRTP. And then if you've been participating before today, we've gone over information about the assessments, a qualified individual, family and permanency teams, and the out-of-home placement plan. But today we'll be concentrating on that court approval and then also the ongoing court involvement that has to take place. So that's why I'm saying, in the beginning, I said that Minnesota Child Welfare Training Academy website is just so crucial, because what we're showing you is a piece of the puzzle to the big picture you will see of all the trainings that we've done so far. And then this is a slide that Ralph McWhorter made to attribute to him, but just as a visual, if you're a visual learner. So this is the federal law. And so I could only do a circle for the graph, that was me, but I just wanted to kind of pinpoint us to that's what we're going to be concentrating on today. But that again is just a very small picture of the whole picture. So it is helpful to know that today it's fitting into this whole process that is much longer than just the court review process. And in Minnesota, as you can see at the 30-day mark, there's assessment by qualified individual, and Paul will be going over this later, but we have built into our Minnesota law that basically, if you will, the assessment needs to be done before placement, but obviously there are emergencies that happen and that placement has to take place before the assessment can be completed. And that Paul will go over later, I believe. And with that, what we want to move into next is the Minnesota process, and I will hand it over to Paul. Thank you.
Yep, thanks, Jen. So today we're going to be talking about 3 types of QRTP hearings. There's the initial court review, as Jen mentioned, is required within 60 days of a QRTP placement. There's ongoing court reviews for children who are in QRTP placements. And then there is review of children who have been in QRTP placements for an extended period of time. Rebecca will talk about the court process for each of these, but before she does, I will provide some context for the QRTP court review process. So a QRTP is a group care setting that meets the federal and state requirements to be licensed and certified as a QRTP through the Minnesota Department of Human Services. There was, as Jen mentioned, a previous webinar on QRTPs on the Minnesota Training Academy website, and you can look at that if you want to go back and review it. It's recorded. Now, the license and certification requirements include that a QRTP is trauma-informed treatment model, that it's registered or licensed nursing staff that's available 24/7. It's accredited by an independent nonprofit accrediting organization approved by the U.S. Department of Health and Human Services. The QRTP must do family outreach as part of the child's treatment plan, and the QRTP must provide discharge planning and 6 months of family-based aftercare. Next slide, Jen. When the juvenile treatment screening team recommends placement in a QRTP, the county agency or initiative tribal staff arrange for a qualified individual to conduct a QRTP assessment. The county agency or initiative tribal staff also assemble a family and permanency team. If the QRTP assessment recommends placing the child in a QRTP and the agency has the placement authority over the child, then it makes appropriate referrals. It makes referrals to appropriate QRTPs. Upon acceptance by a program, then the agency places the child in that QRTP. The QRTP assessment by the qualified individual must be completed prior to or within 30 days of the child's placement in the QRTP, unless, as Jen said earlier, due to a crisis, the child must be immediately placed. If that's the case, then the QRTP assessment must be completed within 30 days of the child's placement. Upon receiving the QRTP assessment from the qualified individual, the agency prepares its court report. You can go on to the next slide, please. I want to talk a little bit about the QRTP assessment. In case you haven't seen that, there's a webinar, a complete webinar on this. I'm just going to talk briefly about the format and the form that's used for the QRTP assessment. The form is on eDocs. On that slide was the link to the QRTP assessment form. The QRTP assessment is filed with the court by the agency when the agency files its court report. So let's go over some of the components of the QRTP assessment. Next slide, please, Jen. The QRTP assessment includes recommendations from the qualified individual. That recommendation can be, is the child's family able to meet the child's needs at this time? Can the child's needs be met in a foster family home or by kin at this time? When the qualified individual is filling this out, if they click yes or no, a text box appears for them to put in more information in terms of what's needed to support that placement, or if they can't be supported in a family foster home or in their own home, the reasons why they can't. The third recommendation is, can the child's needs be met in a specialized residential setting? Those would be those things that Jen had on her screen, that there's webinars coming up later this month on each of those, or in another residential facility other than a QRTP. And the fourth recommendation is that QRTP is the most effective, appropriate, least restrictive setting consistent with the child's short-term and long-term goals in their permanency plan. Next slide, please, Jen. The QRTP assessment also includes family and permanency team engagement. So the qualified individual, as part of the assessment, describes their engagement and consultation with the child, with the parents, with the child's tribe, and with family and permanency team members. Next slide, please. Incorporating the child's cultural needs is also part of the QRTP assessment. And on this slide, you can see that culture includes a number of factors, and it's not even limited to those, but the entire culture of the child should be incorporated into the QRTP assessment. Next slide. If the QRTP assessment recommends something different from what the child or the parents or the family and permanency team or the tribe want, the qualified individual provides an explanation as to why. So for each of these questions, if no is selected, a text box will open instructing the qualified individual to explain why they have not adopted what that particular person or the tribe wants. Next slide. The QRTP assessment uses the Child and Adolescent Needs and Strengths tool, more commonly called the CANS tool. And the assessment should include the outcome from the CANS, the child's strengths and the child's needs as identified through the CANS, and the QRTP, and the qualified individual develops the child's short and long-term mental health goals and behavioral health goals. Next slide. I went through that just to give you some idea of what the court will have, because the QRTP assessment will be filed with the court. And so it's helpful for you to know what the court is going to have before it. There'll be the court report from the agency and also that QRTP assessment. As I said earlier, a QRTP assessment must be done within 30 days of placement of the child in a QRTP. What I'm talking about, we're back to this slide, the top row, the box on the far right says a court report filed within 35 days. What we're really getting at here is if the child has been in a QRTP for 30 days and the QRTP assessment has just been completed recommending QRTP placement, then we're really down to only 30 days for the court to approve or disapprove that placement, that QRTP. And so the guidance for the agency having 5 days to do their court report is to give the court enough time to actually look at the information and make the review and review the QRTP placement within the 60-day requirement of placement for the court. Next slide, please. If the QRTP assessment comes back saying that QRTP is not recommended, the agency must move the child out of the QRTP and transition the child to a less restrictive setting within 30 days. Now, there's no need for a court review within 60 days because the child's no longer in the QRTP. The agency will then file that QRTP assessment with the court at the next required hearing. So what we're talking about here is a QRTP assessment that's not recommending QRT placement. It gets filed with the court at the next required hearing. So the court is aware that that assessment was done and that the assessment came back saying not recommending QRTP placement. Next slide. So here we have what the court considers at that initial QRTP placement. Rebecca will talk in more detail about this. Next slide, please. And this is the, thank you. This is the information that the agency provides to the court. There is a request for a hearing or for a court review and order without a hearing. There's the report prepared by the agency, the qualified individual's QRTP assessment, an updated out-of-home placement plan. The agency would update it based on the results of the QRTP assessment, and then other information provided by the parties. Next slide. So I just want to talk briefly about just some differences between these three types of QRTP hearings. At the initial review, the court review happens within 60 days of each QRTP placement. That can be at a court hearing or without a court hearing, depending on the circumstances. And again, Rebecca will go into more detail. Next slide. Ongoing reviews of QRTP placement. The agencies submit evidence at each administrative review, court review, and permanency hearing, how the QRTP placement is going and what the expectations are for that. Next slide. Next slide. Oh, so here we have when a child is considered to be in an extended QRTP placement. And if that is the situation, then approval signed by the county social services director of the responsible agency for continued QRTP placement is required. Next slide. Jen talked about when this all takes effect, September 30th, 2021. Children placed in congregate care settings prior to September 30th are considered legacy and will fall under previous placement provisions until they move to a new congregate care setting. So children entering QRTP settings or moved to QRTP settings on or after September 30th are subject to the QRTP assessment and court review process that we're discussing today. Next slide. There's court report templates in SSIS. Those are being updated with QRTP requirements. It's an option for counties and initiative tribes to use those templates in SSIS. Eric will give the location. You might be surprised by that. That was supposed to be a behind the scenes instruction, but there it is. Okay, so those new court report templates will identify the information that's listed on this slide. I don't really need to go through it with you. Next slide, please. We have also, in SSIS, there will be a QRTP addendum that details information specific to a child in a QRTP placement. So regardless of what court report you're using, you can attach the addendum to that court report. and file it at the same time as the court report. Just based on how court administration receives filed documents, it would be helpful if your court report identified that you're also filing a QRTP addendum so that the court and court staff know that that is there. Next slide. Also, in SSIS templates, we are updating a voluntary placement addendum. So children who are placed in a QRTP under 260D or voluntarily placed under 260C.227, the QRTP requirements also apply to them. And so this is a voluntary placement addendum that can be used. It's a template on SSIS. Again, you should indicate on your court report that you are also filing a voluntary placement addendum, just so that the court and the court administration and court staff know to look for that when you file that. I'm now going to turn it over to Rebecca to talk about the court review process. Thank you.
Thank you, Paul. Good afternoon, everybody. Jen, if you want to move to the next slide, please. I'll take us through the court review process. And Paul has outlined for us kind of some of the big picture buckets of what that looks like leading up to, and then kind of moving through that process. But really, it's important to step back then too and think about, why is the court review necessary? And the kind of the whole emphasis of Family First is to really add these protections for kids who are in these settings, and to ensure that they're really in the most appropriate setting at all times. And all of those pieces that we've been talking about really need to happen, in addition to the information that I'm going to go through about what's necessary in terms of court findings and orders, in order for the resources to flow through for the child to remain in that placement, for the funding and other things like that. So let's talk a little bit more about what information is needed at the initial review. And so, as Paul mentioned, there's one of the new components of this is that within 60 days of a child being in a QRTP, there needs to be an initial review by the court. And the court, as part of that, is going to be looking at the information that's filed from the county agency, or the that has information about where the child is currently located, the assessor's report. And so one of the first things the court's going to be looking at as part of that initial review is, what placement is recommended, where is the child, what was recommended, certainly, by the agency and the qualified individual. And when that is a QRTP, the court's going to be looking then at, why is a child, why is it that their needs can't be met in a more family setting, either with their family or in a foster family home, with the use of in-home services or outpatient services. Is this truly the most appropriate setting for the child, with the least restrictive environment? And you'll see a note on the slide too that lack of available alternatives or placements can't be a reason. So we really need to know for sure, that this is the most appropriate place for this child. And the court adds this additional layer of review to look specifically at those things. And then also, how is this placement consistent with the short-term and long-term goals that we have for the child? Next slide, please. And so if it's an out-of-state QRTP, there's additional components of what the court would need to look at, which is, what are the compelling reasons why the child's needs can't be met in an in-state QRTP? And then, what were the child and family permanency team's placement preferences? And that would include the tribe preference if it's a case where ICWA applies. And the court, as part of that, is going to need to look at, does the qualified individual agree? Was there some disagreement between the child and family permanency team and the qualified individual, or is there some agreement there? And if there has been some disagreement there, why did the qualified individual recommend something different than what that team recommended? So all of that taken together is going to be things, the court's looking at to ultimately make a decision about whether the child's needs can be met in a different environment with family, either in the family home or in a foster family home, through additional supports or any other, resources like that. If it truly can't, and the court agrees that the QRT, that the child should be away from those settings, then the court needs to look at, does this QRTP provide the most effective and appropriate level of care in the least restrictive environment? And again, is it consistent with the short and long-term goals that we have for the child? So all of that taken together results in a written order from the court that either approves or disapproves the child's placement in the QRTP. And that could happen a few different ways. It could happen as a standalone order, an order that just addresses that initial review, the approval or disapproval, or it could be something that is combined with another written order in the case that addresses that if there was another event scheduled to occur within that 60-day period. And so we really anticipate that, to the extent possible, that the initial reviews likely will happen along with another event, if there's another event that's going to bring everybody together in a written order, or that they'll likely happen through an administrative chambers review with a standalone order issued to that effect, unless somebody does request or see a need for a more formal hearing on a standalone basis. And so what you'll see on your screen now is some information about ongoing reviews, because not only is there this requirement for the initial review, but on an ongoing basis at every review and permanency hearing, the county is required to submit evidence of these items, that there's an ongoing need for the child to receive that treatment. What specifically is being met by that treatment? How long is the child expected to remain in need of this additional treatment? And what efforts are being made to prepare the child to transition to a family? And the idea, again, being that once a child is in a group setting like this, in a QRTP, that they are constantly, these questions are constantly being asked and reviewed at every time that we're reviewing everything else with the case, so that we're constantly ensuring that this continues to be the most appropriate setting for the child. So what you'll see now on your screen is some of these additional components that may apply as part of those ongoing reviews if it involves, again, an out-of-state QRTP, looking again specifically on what are the compelling reasons why the child needs to be outside the state of Minnesota to receive this specific type of treatment in this setting. And then if it's a situation where a child over time has been in the QRTP for a significant amount of time, called an extended QRTP placement, has the agency head approved the continued placement in that setting? And that should be documented in the social worker report. And I think Paul had mentioned this earlier, but just as a reminder that, that extended QRTP placement is defined as being, either 12 consecutive or 18 non-consecutive months in a QRTP for a child 13 or older, or 6 consecutive or non-consecutive months for a child who's younger than age 13. Next slide, please. a lot of questions that people had, I think, as we've navigated some of this stuff has been, how does this affect 260D voluntary foster care for treatment cases? Because in those types of cases, oftentimes the court isn't notified about a placement until the child has been there for up to 165 days. And so what you'll see on your screen is just a quick overview showing kind of where it is now, and then what is going to be the requirement after September 30th. And again, this won't be in all 260D cases, but in 260D cases that involve a QRTP placement, the court will need to be notified of that placement earlier, so within 60 days of that placement, so that the court can do that initial review and approve or not that placement in time for all of these other things to be in place as well. So once that happens, and there is that initial review, and again, that can be done administratively through a chambers review, unless somebody or the court feels there's a need for a formal hearing. We're anticipating that the majority of these will be handled administratively as a chambers review with, a standalone order being issued to that effect. Then it's going to be subject to all the ongoing review requirements, with the first continuing hearing occurring when the initial review would have occurred at 175 days of placement, or within 10 days of receiving the report that's filed within 165 days of placement. And another question that I think a lot of people have had is, how does this apply to juvenile delinquency cases? Because there's a lot of variation across the country in terms of the impact that states are feeling in that context or not. And really, it has to do with how 4E reimbursement funds are drawn down or not for placements in that context. And so what you'll see up on your screen is just a little snapshot of what we've, in looking at how this impacts our state, what we've identified as the impact, which is that it's probably not going to affect very many juvenile delinquency cases, cases before the court and that kind of thing. But certainly in situations where it does, it's subject to all of the ongoing, the initial review and all of the ongoing review requirements, just like all of the 260C and 260D cases themselves. And next slide, please. And so I just want to point you to some additional resources and where you can go for more information from the Minnesota Judicial Branch. We do have a help topic on our public website that's listed as Family First Prevention Services Act, FFPSA. And that's where you can find some resources that we've put together, different training tools as we're developing them. Sort of a checklist of things to think about as you're preparing for the court process or going through the court process, and additional training events that are coming up. We have some trainings coming up September 21st and 22nd for CGI teams and other child protection stakeholders in the community. And then our website, or our email address is also listed up there, cgi@courts.state.mn.us. If you have any additional questions or a request for additional support as we navigate through these changes and prepare for implementation on September 30th. And now I'll turn it over to Eric. Thank you.
Thanks, Rebecca. So the next couple of screenshots, we're going to go over the enhancements to the court action screen in SSIS. And as you all may recall, if you work with SSIS frequently, you can create court actions under the participants node, under the ICWA folder, and also from the case details folder. So under the court type field for QRTP placements, workers are going to select either juvenile or tribal from the drop-down menu list. The next field deals with the petition type. When the court type field is either juvenile or tribal, the following are available petition types: contributing to CHIPS, adoption, delinquency, petty offense, permanency, and DDED. And then you're going to enter a filing date of that petition in the corresponding field. Under petition detail, this field is either disabled or enabled based on the selections made under the petition type, and workers will choose the appropriate petition detail when this field is enabled. Then we navigate to the hearing type date field, and we're going to choose the correct hearing type from the drop-down list. A new hearing type of QRTP placement review has been added to this drop-down for selection. Workers are going to select the QRTP placement review if the hearing is solely for QRTP placement review. And then workers will enter the date of the hearing in the corresponding date field. There's also a new field or verbiage with a checkbox. It says when the hearing type field is valued with something other than QRTP placement review, but the hearing did include the QRTP placement review, workers will select this box. This box is disabled if the hearing type is already QRTP placement review. And then individual workers will choose from the correct order disposition. The next slide here that you see is the child findings tab. This child findings tab functions as it already has. There has been no enhancements to this tab, but I did want to bring it into focus because it is still a requirement. And there are some Title IV-E implications that are tied into the child findings tab. The job aid that I provided to you in the chat goes over and gives kind of a high level overview of the fields and date field requirements of this particular screen. The next screenshot on the next slide is going to show the QRTP placement approval. Now, when individual workers choose 60-day court approval under the QRTP review type under the court hearing tab, this tab will become required and individual workers will have to select the appropriate information in each of the fields. And I'll get to that in just a second here. So this new screen starts with help text and is provided by selecting the blue underlined label to provide guidance for how to fill out this screen. The QRTP placement, you can select the drop-down arrow. If the placement has already been entered in SSIS, you can select that placement and bring it into that field. Then we have the court approval within 60 days. And the decision of the court in regard to the QRTP placement, and the worker will indicate whether the review approved the placement or disapproved the placement. And then we will have a QRTP decision date field where individual workers can select the decision date using a date picker or manually entering that information. Something that I didn't include on this job aid is that QRTP addendum. But the location of the QRTP addendum for your report to the court is found under the chronology node under the work group. And you would search under state documents and report to the court. And there will be that that new QRTP addendum setup tab, as well as document template that workers can use to send that addendum in for their report to the court. I already saw a question in the chat about whether or not SSIS will automatically calculate 60 days in reference to the court actions folder. And I just wanted to provide insight that if a placement is entered into SSIS and that placement has been linked to the QRTP assessment screen, then after 20 calendar days, data cleanup will generate under the person that indicates that a QRTP placement is not linked to a court action record. So again, that's after 20 calendar days. And again, if a placement is entered into SSIS and is linked to a QRTP assessment. And now I will turn it back over to our panelists for the Q&A portion of our presentation. Thanks.
All right, thank you, Eric. We do have quite a few questions and about 12 minutes left in our presentation. So there's a good chance we will not get through them. However, we will post them on the Child Welfare Training Academy website after this is complete. So question 1, will we still be able to claim Rule 5 reimbursement on a QRTP licensed facility?
So as long as the process that we went through today is followed, those funds will be available. And of course, we have not been given guidance from the feds. So as to how that will be kind of followed through afterwards, but we will be getting that. And of course, we will let stakeholders know along the way, but we would, just as all the other funds, the protections, the best interest, contrary to the welfare findings. So those also have to be followed as well, because if those aren't found at the initial removal, then funding doesn't. So even if the QRTP was followed to a T that we went over today, there are all the other laws that we've been working on since the 70s, they still are in effect. And not to go down prior laws, but we still we see many local social service agencies and tribal initiatives. There are cases where we're not even we have challenges with just having those findings and effects. So to say will the funding still be provided? It still depends on everything that the law still needs to be followed. And I don't know if Paul or Becca had anything to add to that, but it's still, so you can follow QRTP, but everything else that we still have been doing and following all along has to be applied as well for funding to continue.
I have nothing to add to that. I think you've answered that, Jen.
All right, thank you.
And I don't have anything either.
All right, moving on to question 2. Is there clarity on what a court review means? Is this an in-person review or a paper review?
I can speak to
Becca,
that.
I'll let you cover that.
Okay, thank you. It could be either one. We in Minnesota, the way that we have interpreted that court review requirement is sort of a bit of a hybrid approach where it could take either one of those forms. What the state statute talks about is that, in situations where somebody requests a formal hearing or the court in its discretion feels that would be appropriate and needed, it could certainly be a formal hearing, but otherwise it could be handled administratively as part of a chambers court review. And so I think we're anticipating that the majority of the reviews, especially that initial review that needs to happen so quickly, will probably be handled administratively in most circumstances, unless there's another event already scheduled in the case where everybody's going to be coming together within that 60 days, then it might just be heard in connection with that. But otherwise, I think the vast majority of these are going to be handled administratively. Was there anything that you would add to that, Paul?
Well, just to reemphasize, for many jurisdictions, it will be hard to get a hearing within 60 days of placement. And so the flexibility of having the court review it administratively is built in so that we can meet that 60 days of placement within 60 days of placement requirement.
All right, thank you. Moving on to question 3. I'm going to give this one to Deb. Why does it say 35 days on page 18? And by page 18, the person asking the question meant slide 18.
Actually, I think I would answer that if that's okay with Deb. So again, we have this deadline of 60 days from placement that the court has to have made its review and issued an order either approving or not approving the QRTP placement. And so the preferred procedure would be that the QRTP assessment is done before the placement ever happens, because then it's easier to have that full 60 days for the court to have that full time for its review. If there's a situation where that QRTP placement actually happens before the QRTP assessment is done, then the qualified individual has 30 days in which to complete the QRTP assessment. But that 30 days is then, that only leaves 30 days for the court to review the QRTP placement if the assessment isn't available to the court for 30 days after the child is in placement. So the guidance is that the agency would turn that around as quickly as possible once it gets the assessment, hopefully within 5 days, get all the information to the court so the court has enough time to review the information and issue its order within 60 days of placement. Now, that's not the best, in my opinion, to have that happen so quickly. And that's why the preferred process would be for the QRTP assessment to happen before there's ever a placement. Because once that QRTP placement happens, that's what's going to trigger these other 60-day deadlines and 30-day deadlines. I don't know if you want to add anything to that, Rebecca or Jen?
You know, I would just emphasize too, like you had mentioned, Paul, I think just that, you know, even at its maximum, you know, 60 days is a tight turnaround. And so I think that's a really good point, and something that we've been really thinking through in terms of, you know, how all of that is going to work as part of the court process. So I think to the extent that those things, you know, as you mentioned, can happen before the placement, I think that's certainly, you know, helpful when it can happen that way. But otherwise, I don't have anything. I think you did a really good summary, Paul.
All right, moving on to the next question. Is there a template or format for the agency to report to court?
Yes, it's located in SSIS under chronology and report to the court. You'll see an addendum for QRTP with a setup tab and a follow-up template.
And Eric, is that currently in there or it will be by September 30th?
It's in the QA environment that I test in, and I imagine that it will be up and ready to go by September 30th.
Yes. So if you're going on SSIS today and you don't see
Correct.
it is coming.
Yes. Thank you, Paul.
All right, thank you. For ongoing reviews, are they every 90 days or every 180 days?
Go ahead, Paul.
Rebecca. No, you go.
I was just going to say, you know, so the statute, you know, talks about reviews being on an ongoing basis at every review and permanency hearing that's scheduled within the case. So, for example, for 260C cases, Because reviews would need to occur at least every 90 days, for those types of cases, it would need to be at least every 90 days. But for example, in 260D, voluntary foster care for treatment cases, those wouldn't need to be more frequent than what they already are, on an ongoing basis within that case. Does that answer the question? And I don't know if there's anything additional you wanted to add to that, Paul or Jen.
I would just say it a little differently, but it's really the same thing. The QRTP process adds an additional initial review within 60 days of placement, but then all other reviews are based on what's required in the underlying cause of action. So you're going to have a 60-day review of a 260D placement. That's new. But then your next review is going to be at 175 days. Or as Rebecca has said, if we're just in a CHIPS proceeding and we're reviewing every 90 days, you're going to review that QRTP placement every 90 days. Just whatever the underlying cause of action requires for reviews, those remain in place, and you review the QRTP at every hearing.
Okay, thank you. And Paul, did you want to close us out today? And then the questions that we did not get to will be posted on the Minnesota Training Welfare Academy website.
So thank you everyone for joining us. And this webinar has been recorded, and so it will be posted. We try to get them posted within a week on the website. So if you are telling other people about it, they will have the ability to go on the website, the Minnesota Training Academy website, and watch the webinar as well. But we appreciate all of you coming, and we appreciate the work you are doing to implement FFPSA, which is a good change in terms of our child welfare system. So thank you.